Hello, hello. Hi. Hi. I'm back. Augie, hi. Hi, beautiful Augie. Hi, beautiful Dipsy. Happy Saturday, Debbie. Hello, Debbie. I don't know if you're still here, but thank you for stopping by. I appreciate you. Always good to see you. We just finished another live and now we're back. We're going to continue. We're going to read Diddy documents. Yes, we are. I got all of them. So I got the new motion for bail, and then I got their response yesterday, and then I got the new lawsuit from, I guess it was like an older case, but someone by the name of DeWitt has now filed a lawsuit against Diddy and his bodyguards. So that one is dated 11/03, but it was posted to the court system, I believe, just yesterday. So it is a pretty new document. Thanks for being here. I'm going to share and we're going to get started. So this first document, it's motion for bail, filed 11/8. I haven't read through these, so bear with me. Thanks for being here. Welcome to my channel. Okay, so that basically states, please take notice that upon declaration of Mark Agnifilo dated November 8th, the exhibits attached thereto and accompanying. Okay, we don't need to look over that document. And now we'll go through the memorandum. And this was filed on 11/8 as well. I'm just going to read the introduction, the parties, and the allegations. So let me... Okay, there we go. Just want to make sure you guys can see. Hi, 4 Chihuahuas. Good to see you. Thanks for being here, love. Introduction. Mr. Sean Combs, through his counsel, renews his motion for release pending trial. This renewed motion is based on a significantly updated proposal bail package, new evidence, as well as changed circumstances regarding Mr. Combs' ability to prepare for trial while detained. First, Mr. Combs proposes an updated bail package that is far more robust than the previous proposal, as well as other bail packages routinely approved by courts in this circuit. The proposed package even surpasses a bail package recently requested by the government in a comparable case in a neighboring district. The updated proposed conditions, which include home detention with a strict 24/7 security monitoring arrangement and near total restrictions on Mr. Combs' ability to contact individuals other than counsel, will reasonably assure the appearance of Mr. Combs as required and the safety of any other person in the community. Second, new evidence received in discovery from the government undermines the primary basis on which the government initially sought and Judge Carter ordered detention. The evidence makes clear that the government's case is thin. It confirms the defense's initial description of the events depicted in the March 2016 video recording. The video is not evidence of coerced, quote-unquote, freak-off, but rather a minutes-long glimpse into a complex but decade-long consensual relationship between Mr. Combs and victim one, which I'm assuming is Cassie? I'm not sure. Additionally, the new evidence refutes the government's proffer at the initial hearing regarding a potential second alleged victim. And the new evidence confirms that the government's obstruction and the witness tampering allegations at the initial bail hearings lacked a factual basis. Third, Mr. Combs' current conditions of confinement infringe his constitutional rights to participate in his defense. Given the argument's amended estimate of the amount of discovery in this case and its unique format, including voluminous video and photographic evidence, Mr. Combs' releases on the proposed conditions is necessary so that he can review the discovery and prepare for trial. Despite the MDC's best efforts to facilitate the defense's team's needs, the current arrangements make trial preparation impossible as the recent multi-agency sweep of the facility and resulting lockdown. The Bail Reform Act and the Constitution demand more. Accordingly, Mr. Combs moves to reopen the prior detention decision and the request release on the proposed updated conditions detailed herein. So this is his attempt. Hey, Guidance, good to see you. Thanks for being here. So he's asking to be let out. Are we surprised? Let's move on. The court can revisit the prior detention order under two separate provisions of the bail reform. Section 3142 permits a new bail hearing at any time before the trial if the judicial officer finds that the information exists that was not known to the movement at the time of the hearing and that has a material bearing on the issue whether there are conditions of release that will reasonably assure the appearance of such person as required and the safety of any other person in the community. Section 3142 expressly permits this court to revisit a prior detention order and release a defendant in the custody to the extent that the judicial officer determines such release to be necessary for the preparation of the person's defense or for another compelling reason. Moreover, the court has inherent authority to reopen the hearing even when the circumstances do not match, where, as here, the case has been reassigned and is not bound by prior rulings and should review the record de novo. The proposed updated conditions of release are sufficient. The defense proposes the following updated bail package, which will assuage any concerns of danger and obstruction and will ensure Mr. Combs' appearance in court. So he's trying to get out again. Is he gonna stop? Number one, a $50,000 bond, which we knew of before. Wait, $50 million bond. My bad. Co-signed by Mr. Combs and his mother, his sister, the mother of his oldest daughter, the mother of his youngest daughter, and his 3 adult sons. His sister, the mother of his oldest daughter. Where does Kim Porter come into play? Is that Kim Porter? Wait, the mother of his oldest daughter, the mother of his youngest daughter, and his 3 adult sons. Am I tripping? Let's move on. Secured by the equity in Mr. Combs' residence located in Miami, Florida, an encumbered property appraised at $48 million. Further secured by the equity in Mr. Combs' mother's home in Miami, Florida. Full home detention at his residence in Miami or a suitable location in New York with GPS monitoring. Counsel will travel to his location for any in-person meetings with Mr. Combs or have counsel meetings via video. To the extent Mr. Combs' travel is necessary, his travel will be restricted to the Southern and Eastern Districts of New York and the Southern District of Florida. Mr. Combs must pay all or part of the cost of location monitoring. Number 3, 24/7 monitoring by disqualified security personnel approved by the government and pretrial services. Number 4, Mr. Combs will have no access to telephones or the internet except during calls with counsel to be arranged by security personnel. You're telling me if he gets let on bond, he's not going to use his phone or any social media? Like Diddy can't pay someone to have a different phone, a whole ass different number, and make a fake account or whatever to access social media. No, I don't buy it. Hey, Scott, good to see you. Thanks for being here. Restrict all visitors except for counsel and pre-approved list only consisting of specific family members with the consent of pretrial services in the government. Family visits will be scheduled only with pretrial services prior approval. Security personnel will monitor family visits. Mr. Combs shall avoid all contact directly or indirectly with any person who is or may be a victim or witness in the investigation or prosecution. Number 7, Mr. Combs will consent to provide pretrial services randoms access to the residence. Number 8, Mr. Combs' passport was surrendered to his counsel on April 1st, 2024, which counsel will provide to pretrial services. The following members have also surrendered their passports to counsel, who will provide them to pretrial services: Janice Combs, Chance Combs, Jessie Combs, and Delilah Combs. Where are these? Where's his son? Is his son in this? What's his name? What? I'm tripping. Janice, Chance, Jessie, and Delilah. I thought he had a son named Justin. No? Am I wrong? Counsel will continue efforts to sell Mr. Combs' airplane. The defendant shall submit to prior testing for a prohibited substance if required by the pretrial services officer or supervising officer. Testing may be used with random frequency and may include urine testing, with wearing of a sweat patch, a remote alcohol testing system, and or any form of prohibited substance screening or testing. The defendant must not obstruct, attempt to obstruct, or tamper with the efficiency and accuracy of the prohibited substance screening or testing. Mr. Combs must participate in a program or counseling if directed by the pretrial services office or supervising officer. All other standard conditions of pretrial release. Additionally, for the avoidance of any doubt, and as stated during the September 18, 2024 hearing, if Your Honor wants something more or different, we can do whatever Your Honor thinks is necessary. These proposed conditions present an extremely substantial comprehensive bail package for any defendant and are plainly sufficient to warrant pretrial release under Code 3142. For example, the Second Circuit affirmed the release on similar but far less restrictive conditions of a defendant charged in multiple counts, including drug trafficking, firearms, sex trafficking, and related offenses. Fox is just one of the many cases including that such conditions are adequate. Indeed, the government recently requested pretrial release for two similarly situated defendants, including a CEO accused of sex trafficking dozens of young men, including through witness intimidation. Who is that referring to? Indeed, the government recently successfully requested pretrial release for two similarly situated defendants, including a CEO accused of sex trafficking dozens of men, including through witness intimidation. In Jeffries, the government sought release despite claiming the defendants, quote unquote, relied on services of a security company to surveil and intimidate, thereby securing their silence. The conditions of release requested in Jeffries pale in comparison to the conditions proposed by Mr. Combs here. There, the government requested bonds of $10 million and $500,000 respectively for the two released defendants, and release to home detention with GPS monitoring. The requested conditions include no additional security or surveillance arrangement whatsoever. Hey Jojo, good to see you. I'm glad you made it back. Hi, my traveling tarot. What's up? Thank you for making it. Welcome to my channel. The conditions proposed here are more restricted than in most of the other cases cited above. Mr. Combs would be in the custody of professional private security officers, whereas most of the cited cases imposed only electronic monitoring or placing the defendant in the custody of a relative alone. The proposed security monitoring is precisely the situation contemplated by the statute. It specifies that the conditions may include the defendant, quote unquote, remain in the custody of a designated person who is, quote unquote, reasonably to assure the judicial officer that the person will appear as required and will not pose a danger to the safety of any other person or the community. As Judge Rakoff has explained, if a defendant is strictly confined to an apartment with electric monitoring, there's no meaningful likelihood he will engage in any conduct constituting danger or tamper with witnesses. Moreover, although the court should make its own determination, the updated bail package proposal mitigates the specific concerns that Judge Carter identified during the initial September 18, 2024 detention hearing. During the hearing, Judge Carter's primary concern appeared to be a risk that Mr. Combs could obstruct justice and intimidate witnesses using third parties. Specifically, that he would still have access to employees and other individuals and could obstruct justice and intimidate witnesses through those folks through even coded messages if necessary. However, under the proposed updated bail conditions, Mr. Combs would not have access to quote unquote employees and friends and the like, and would not quote unquote speak with these employees. So Diddy's saying that if they let him out on bail, he's not going to talk to any of these employees and not use social media. I don't believe that. What do you think? The section, okay, let me move on. Reviewing the factors de novo in light of the new evidence demonstrates that detention is not warranted. The indictment has 3 counts: racketeering, conspiracy, sex trafficking by force, fraud, or coercion, and transportation to engage in prostitution. The racketeering conspiracy count does not allege that Mr. Combs himself engaged or conspired to commit any particular racketeering act, and the grand jury did not need to find probable cause regarding any such conduct to return a true bill. This is because 18 U.S.C. does not require proof of the commission of any racketeering act or even an overact, nor does the defendant have to agree to commit or facilitate each and every part of the substantive offense, or even the 2 predicate acts of the alleged conspiratorial agreement. For purposes of bail, then, there has been no affirmative grand jury finding that Mr. Combs committed or conspired to commit any of the acts set forth in the pattern of racketeering activity included in the indictment at paragraph 13. Count 2 alleges that Mr. Combs committed the crime of sex trafficking starting in 2009 and concluded 6 years ago in 2018 against a single victim, victim 1. The indictment contains no allegation of additional victims or minor victims. There is no allegation that any sex trafficking occurred in the last 6 years. Although count 2 triggers section 3142, presumption of detention, it is only the charge that does so. Of course, even in a presumption case, the government retains the ultimate burden of persuasion by clear and convincing evidence. Over the past 6 weeks, the defense has received approximately 23.5 terabytes of discovery material. Whoa. The material reveals new information about the case, the evidence, and the government's previous bail contentions that was, quote unquote, not known to the movement at the time of the hearing. The new material demonstrates that the government previously misrepresented the weight of the evidence, and it undermines the government claim that Mr. Combs presents a danger. First, the discovery includes blank, it's blacked out, redacted, that refute the government's core sex trafficking allegations. Second, this new discovery negates the government's claim at the initial detention hearing that there is a potential second victim. Third, The discovery shows the government's obstruction and witness tampering allegations were entirely misleading. And finally, the government failed to disclose to the court information concerning blank testimony that undermines its claims. We take each in turn. So they've blacked out some stuff here, as you can see on the documents. I didn't review these before I read them with you guys, so I might have to edit these and try to uncover what's below these. As noted, the government's allegations of sex trafficking relate to one woman with whom Mr. Combs shared an 11-year relationship, Cassie. Included in the discovery materials are blank. And then this whole thing is blacked out. This is just, I'm not blacking it out. This is the court document. So there's a whole page of redacted information that's going to come play into trial. I feel like all that redacted information is stuff we need to know. It names other celebrities, other people. That's why they want to be What do you think, my traveling tarot? What do you think? Yeah, you know that. You're like, you know, a lot of celebrities are involved. The first mention of any sex trafficking or unwanted sexual contact involving alleged victim 1 was in November 2023, 5 years after the couple's 2018 breakup. The evidence shows these allegations were merely attempts to obtain a financial windfall from Mr. Combs. In the spring of 2023, victim 1 revealed to one or more others that she needed money to support her small family. She told others that she had started writing a book about her relationship with Mr. Combs. In June of 2023, she texted Mr. Combs' employee that Mr. Combs should contact his lawyer to have his lawyer speak with her lawyer. She followed up on this on June 15th, 2023. The same day, her lawyer contacted one of Mr. Combs' lawyers who, expecting that she might make an extortionate demand, recorded the conversation. During the approximately 18-minute recorded call, the lawyer confirmed that victim 1 was writing a tell-all book and that Mr. Combs could buy the exclusive rights to the book for $30,000. Wait, $30 million, which would ensure that it was not published. 30 million, my bad. Mr. Combs and his lawyers considered this extortionate demand and did not pay the money. In the fall of 2023, victim 1 pursued a different strategy. The Adult Survivors Act, which suspended the traditional statute of limitations for sexual assault claims, was scheduled to expire on November 24th, 2023. In November, victim 1 indicated in discussions between her lawyer and Mr. Combs' lawyer for the very first time, 5 years after the relationship ended, that she had been abused by Mr. Combs, again, demanding $30 million. To be clear, the statute of limitations for non-sexual assault, battery, and other alleged offenses were subject to the typical statute of limitation for those torts. Accordingly, the only way a plaintiff could avail herself of the ASA is by alleging sexual assault. Thus, on November 16, 2023, days before the ASA expired, victim 1 filed a civil complaint alleging inter alia, which means sex trafficking. The case settled quickly without any admission of wrongdoing. With the release of the civil complaint, law enforcement saw an opportunity to build a criminal complaint against Mr. Combs. Discovery shows that within days of the civil case settling, this investigation began. The government recycled victim 1's allegation, but the case requires her potential testimony, which will be refuted by years of written correspondence and other documentary evidence. The alleged second victim is not a victim at all. During the initial Bell hearing, the government alluded to a potential second victim, arguing that Mr. Combs' contact with his perpetrated victim were evidence of obstruction. September 18, 2024. However, and then it's redacted. 2 whole sentences are redacted. Despite the government's claim, blank and blank, that this woman is a sex trafficking victim, the defense has learned the government has not even spoken to her, nor nor was she the target of any obstructive conduct by Mr. Combs. Wow. The government clearly misled the court and concealed the true facts during the initial bail hearing. For example, the government knew blank. The government also knew blank. But the conduct was nothing of the sort which the government clearly knew. Indeed, the discovery confirms blank. What are they blanking out here? That's super sus. What are they blanking out? Are they talking? They were talking about 𝗂𝗄𝗃, but now it seems like they're saying that the feds knew a lot more again, that they say they know. I don't know. This is weird. Let's move on. The discovery claims, the discovery also undermines the government's argument that Mr. Combs attempted to tamper with other individuals, including grand jury witnesses. During the previous bail hearing, the government outlined what is billed as obstructive communications with grand jury witnesses in June and July of 2024. On September 18, 2024, it is further characterized by Mr. Combs' communications with another person as witness tampering. Judge Carter considered this the government's most persuasive evidence, posing the questions to the defense, quote unquote, if he's aware of the April 1st, 2024, then again, why is he contacting witnesses in June and July of 2024? And, quote unquote, what would be the purpose of Mr. Combs continuing to speak to that witness after September 11th? But the recent discovery now corroborates the defense's arguments at the initial bail hearing. At the hearing, Mr. Combs' counsel explained that his contacts with these people were not in any way obstructive. One grand jury witnesses and contacted him, not the other way around. The September 2024 communications were with an individual represented by counsel who wanted to make a public statement. And to the extent individuals were contacted, defense counsel explained that to conduct a responsible defense investigation, it must, of course, continue to interview witnesses. In opposing these arguments, the government misled the court and concealed the actual content of the communication. The truth, however, is that a grand jury witness, the one with whom Mr. Combs has not spoken in several years, and then it's all redacted. There's like 4 sentences redacted. These statements, which the government conveniently withheld from the court, in no way evidence obstruction. So there's no way it's evidence obstruction. Why is it blacked out? The same is true of the individual whom Mr. Combs contacted in September of 2024, and then black out again. But during its proffer to the court, the government concealed these facts, which completely undermine its claim that at the timing of the contacts with the person in September 24 suggest obstruction. I know he did contact Dawn from Danity Kane. Did we read that lawsuit? If not, I know it's coming up on my schedule, but I know, is that who that is, Dawn? Mr. Combs is entitled to have his counsel conduct a thorough defense investigation. Indeed, his constitutional right to the effective assistance of counsel demands it. At times, counsel might also need Mr. Combs' assistance and involvement to conduct a proper investigation. Of course, Mr. Combs has the constitutional right to participate in his defense, and if witnesses are contacted to support his defense, that alone does not amount to obstruction or evidence any risk or of obstruction of danger. You call BS because it's obstruction. Defense counsel noted at the initial hearings that based on the defense interviews and investigations, several individuals associated with a male companion agency have stated to the prosecutors that they are paid for their time, not for having sex. Blacked out. This is not a surprise, as the companion agency is not some secretive underground operation. It has been operating in the open for a decade with a website of over 10,000 followers on X, and its operations have been featured in well-known magazines. Its CEO actively courts media attention, starred on a Showtime series about male companions, and has been repeatedly interviewed on national talk shows and national news. According to the CEO, the company's services have exploded in popularity because of all the publicity. So, what? Testimony of blank undermined the government's case. So there's a male companion agency, male sex workers. In other words, the government's allegations are incredibly weak and contradicted by the testimony of its own witnesses and discovery received to date. Hold on, I'm lost. Its CEO actively courts media attention, starred on a Showtime series about male companions, and has repeatedly interviewed on national talk shows and the national news. According to the CEO, the company's services have exploded in popularity because of all this publicity. What are they talking about there? Buppan, hi, I'm glad you made it. Why is the government all shit? These are literal court documents. Like, I had to pay for some of these. Yeah. And they're blacked out. I know. I ain't blacking them out. I'm just bringing this stuff here. I don't know what they're talking about. So there's a male that filed, this is what I'm getting. There's a male that filed something against Diddy, but this male is involved with something on Showtime that involves male companions. I'm confused. If you know about that, let me know in the chat. C. Mr. Combs' character and history and other sections. The Bail Reform Act requires courts to assess a person's character, physical and mental condition, family ties, employment, financial resources, and length of the residence in the community ties, and the past conduct, including history relating to drug and alcohol abuse, criminal history, and record concerning appearance at court proceedings. In addition to Mr. Combs' prior arguments regarding his cooperation to date, we incorporate herein, we note the following. Mr. Combs' character. Oh, geez, here we go. Mr. Combs has never run from a problem. I'm sorry, Mr. Combs. Not y'all telling me, Melly, get your shit together. Oops. Hello, Melly. Yeah, hello, Bun Bun. Hey. Hey, thanks for being here. Is she going to be charged with trying to extort 30 million? Cassie, no. We saw the video. We saw what we saw. Diddy did what he did. The question of whether he abuses females is not a question. Physically or sexually, we have yet to determine that by the courts, right? But we saw that video with Cassie. So I saw what I needed to see. What do you feel about that? Let me know. Okay, let's move on. Happy Saturday, you guys. Thanks for being here. We're on the second document for Diddy. Mr. Combs has never run from a problem. He has more than his share of adversity, as he does now. And he has responded to every such challenge with integrity. Is that true? Is that true, Mr. Combs? Or are your lawyers responding with integrity? Sean Combs was born on November 4th, 1969, at a women's hospital in Harlem, New York. His mother, Janice Combs, was a teacher's assistant. His father, Melvin Combs, died when Sean was 3 years old. His mother and others told him that his father died in a car accident. It wasn't until years later, when Sean was a student at Howard University, that he researched microfiche and learned his father was murdered. Determined not to let her only son follow in her deceased husband's footsteps, Janice was perhaps extra protective of Sean. She raised him with a strong belief in God, religion, and faith and redemption. At the age of 10, he became an altar boy at the parish of St. Charles Borromeo at 282 in Harlem, New York. He also spent his Sundays at the Shiloh Baptist Church at 226 in Harlem. When Sean was about 12, he and his mother moved to Mount Vernon, a small city in the Westchester County bordering the Bronx. Sean attended and graduated from Mount St. Michael Academy, an all-boys Catholic high school, where he played on the football team. His ties to this community run deep. Mr. Combs' career and work history. While a student at Howard University in Washington, D.C., Mr. Combs began working for free at Uptown Records, which was created in 1986 by Andre Harrell to be the first major hip-hop music label in the world. Combs bunched his classes at Howard on Tuesdays through Thursdays and took the train to New York with and learned from Harrell the rest of the time. He quickly distinguished himself by the hard, tireless work. Harrell rewarded Combs hard by making him an executive at the label. However, with hard work comes drive and ambition, and Harrell fired Combs in 1993. Wait, I'm confused. He quickly distinguished himself by his hard, tireless work. Harrell then rewarded Combs' hard work by making him an executive. Then, in 1993, he fires Combs. Instead of seeing this as a setback, Combs saw it as an opportunity. He created Bad Boy Records the same year. The 24-year-old Combs had a vision for a new type of business, one headed by a young Black executive that emphasized Black excellence and achievement. It would reflect a certain style, sound, and sensibility that was modern, hip, and urban. Before long, many of the most talented young artists signed with Bad Boy. In June of 1997, Combs wrote and sang his first song, I'll Be Missing You, with Faith Evans, which was a tribute to his friend Christopher Wallace, better known as the Notorious B.I.G., who was killed in Los Angeles 3 months ago. I'm offended. Why are you? I like Biggie. Not you bringing him up in your bail package demand. Oh, what do you guys think? I'm disgusted. Don't run, but pays his way out of things or bullies. Chris, good to see you. Thanks for being here, love. Snuggles, I see you, Snuggles. What's up? Thanks for being here, guys. How can he still hold his head high up as he's trying to deny shit after all the revolt in the dirt? And that's only the beginning, right, Augie? Yeah, he has his lawyer saying that he's an ethical human being. Allegedly, we haven't seen him in court, so I guess he's innocent until proven guilty. I don't know. But not you bringing up Biggie, like you helped Biggie. You did, but we can get into a whole deep dive. We can go back in time for reals. I was a big fan of Biggie and aaliyah back in the day. In February 1998, Combs' debut album No Way Out won a Grammy Award for the Best Rap Album. Later that year, Combs started the clothing business Sean John, which went on to win Council of Fashion Designers of America awards. Combs was the first Black man awarded the CFDA Men's Designer of the Year award in 2004. In 2002, Combs produced the MTV reality show Making the Band. 5 years later, in 2007, he became the brand ambassador and equal share venture partner with the British multinational beverage company Diageo for the French beverage producer Ciroc. And in 2013, Combs co-founded a television network called Revolt, which carried music videos and programming related to social justice issues as well as music. However, in the wake of the November 2023 lawsuit, he took a leave of absence from many of these ventures. The brief review of Combs' work history shows that Mr. Combs responds to adversity by facing challenges directly and working even harder to overcome them. He does not run from challenges, nor does he cheat or break rules in addressing them. Instead, he takes them head on, as he has already done with the challenge, as he will continue to do so. Vomit. Mr. Combs' contribution to the community. Mr. Combs is also incredibly philanthropic and cares about the community here in New York and elsewhere. Since founding Bad Boy Entertainment, Mr. Combs has actively supported and donated millions to after-school programs and organizations like the Boys and Girls Clubs of America. He has also supported organizations including the National Foundation for Teaching Entrepreneurship, creating opportunities for young entrepreneurs. The cornerstone of his philanthropy is education, and he fulfilled a lifelong dream when he, with a partner, opened Capital Preparatory Harlem Capital Charter School in 2016 to provide high-quality education to inner-city youth in New York City. The success of this initiative led to launch of Capital Preparatory Bronx Charter School in 2020, with Combs donating $1 million to support its development. Mr. Combs has also been proactive in health and disaster relief efforts, having raised over $2 million for the New York City public schools and hosting a virtual dance-a-thon that raised more than $4 million to provide personal protective equipment to healthcare workers on the front end of the COVID-19 pandemic. Mr. Combs' philanthropic work has earned him numerous accolades throughout his career, including the Triumph Award for the National Action Network in 2016, the Superhero Award from Room to Read in 2017, and the Child of America Award from the Carver Foundation in 2018 and 2023, the Icon Award for the Apollo. I'm not impressed. I mean, I am impressed, but I'm not impressed with Diddy still. Because the government argued that Mr. Combs is a flight risk and danger, we further address in brief fashion his history of long-term relationship with families and ties. Although Mr. Combs never married, he has multiple significant long-term relationships that are relevant here. He fathered his first child, Justin, who is now 30 years old, with Misa Halton. He was in a long relationship next with Kim Porter, who he called, quote unquote, the love of his life after her tragic passing from lobar pneumonia in November 2018. With Kim Porter, he shares Quincy, who he adopted, Christian, and twin daughters. He fathered his 18-year-old daughter, Chance Combs, with his longtime friend, Sarah Chapman. Chance is now enrolled at the Tisch School of Performing Arts at New York University. Finally, he has a 2-year-old daughter, Love. Wait, I didn't know. I didn't know that. Okay, don't even get me started, Kim Porter. I have a live coming up on that, I think, in the next 2 days. So stay tuned. Make sure you subscribe. We are going to be reviewing Kim Porter. But I didn't know that he had Chance Combs with longtime friend Sarah Chapman. I didn't know that. Mr. Combs also supports his 83-year-old mother, who recently underwent brain surgery and was in the hospital as recent as this summer with a heart issue. Although Mr. Combs is not his mother's only caregiver, he assists with her medical care. Sean Combs' 7 children and his mother love and support him and need his love and support. The mother of 4 of his children, Quincy, Christian, and the minor twin daughters, Kim Porter, passed away, and his children are now left with an incarcerated father. His minor child, now 2 years old, has not been able to see his father since he was incarcerated and misses him dearly. Really? Hey, Yashira. I need to go back in your guys' comments because I'm over here tripping. Like, really? Your 2-year-old misses you, but you wanted to commit all these crimes? We didn't. I mean, I can't. Diddy should never. Snuggle says Diddy should never have went that liquor company. Never bite the hand that feeds you. And then, right. My traveling says hush money payment, maybe. Did he sue Steel Reserve? Augie says that was his daughter he had with Chapman. I think he had 7 children on. This is wild. Mr. Combs could not adequately prepare for trial while detained at MDC. Incredibly voluminous discovery makes preparation from prison impossible. So how does everyone else do it? How do all the other incarcerated people go through trial and you want special treatment. That's like my problem. It's like, suck it up. Suck it up. You claim to roll with the hard ones, but here you are complaining about being locked up. Why? Because you're famous? Wait for your trial. Shit. I mean, he's like complaining about being locked up. No one made him do any of this. At the October 10th, 2024 status conference, the government described an unprecedented allegedly, by the way, I just have to say my commentary. I'm not a lawyer. I'm just Melly reviewing these documents. At the October 10th, 2024 status conference, the government described an unprecedented volume of electronic discovery. This includes terabytes and terabytes of data extracted from at least 96 electronic devices seized at Mr. Combs' residences in Miami, Los Angeles, and elsewhere. The size of the data collected from Miami alone is extraordinary and totals over 90 terabytes. The data extracted from other devices includes yet more terabytes. Even a single terabyte of data is roughly equivalent to the information contained in the books on the typical academic library. The data here is so large that the government represented it would need to engage in further dialogue with the defense as to how exactly this data could be transferred to the defense team. That is not all. The government further described voluminous subpoena returns and Brady disclosures, and a particularly complicated privilege review process, whereby their filter team will share initial batches of possibly privileged material with the defense for its own review. The government maintains that its investigation is very much continuing, caveating that the more discovery is likely down the road. It further noted that it has yet to succeed in extracting and restoring certain devices, describing such processes as a work in progress and some contingent on quote-unquote technological advances. These hurdles persist and have stalled the defense's review and preparation. The defense recent attempts to confer with the government regarding Mr. Combs' use of a laptop further confirms the conditions are not tenable. There's no way Mr. Combs can review all of the discovery during visits by his attorneys. He needs a laptop so that he can work on his case as often as possible on his own time. You're in federal prison and you are requesting you need a laptop so that you can work on your case as often as possible. Yeah, he misses big. He unalived him. Miss Porter. Yeah, I have a deep dive coming through. Uggy. We're gonna get deep. I like that deep research. I feel like they could have put him away for that shooting. That would have saved 25 years. And oh, Snuggle. Which do you mean? The Biggie shooting? What about 𝗟EᗇE? Can we talk about 𝗟EᗇE? I don't believe that was just. I don't believe that was an accident. I don't. I'm not mentioning that he did Tupac. Ooh, I love me some Tupac too. Hey, Gracie. Good to see you, love. I do. I love me some Tupac. Anyways. He has a laptop so he can work on his case. Wah, wah, wah. Okay, however, even though he has been in custody since September 16, 2024, he still does not have a laptop. Defense counsel has been working with prosecutors since Mr. Combs' arrest to supply him with a laptop that complies with the MDC's security requirements. After numerous delays occasioned in part by the government's misunderstanding of the MDC rules, counsel provided a compliant laptop to the government on October 8th, 2024, nearly a month ago. Nevertheless, as of today, Mr. Combs has still not received or been able to use any such laptop, meaning he cannot review certain files while at MDC. This includes discovery that is critical to his defense and trial preparation. The government has numerous case agents and endless resources at its disposal to conduct its review. Still, it estimates it will need at least until the end of the year to complete discovery. Much of the discovery also includes difficult to review evidence such as video footage and photographs subject to the heightened protections under the protective order. Even assuming Mr. Combs obtains a laptop and counsel is able to share critical discovery with him and visit him at the MDC every day uninterrupted, it will be impossible for Mr. Combs to review this incredible volume of evidence under the present conditions. The current conditions at MDC further impair Mr. Combs' ability to prepare his defense. To start, the frequent lockdowns at MDC persist, as many judges in the South, Southern, and Eastern districts have observed. Inmates said that MDC spend an inordinate amount of time on lockdown. Mr. Combs has not been spared from these lockdowns, which have directly frustrated his defense preparations. They're really using all of it. Hey, Mo. Hi, beautiful. Good to see you. Just last week, the Long Trouble facility was a subject of a multi-agency law enforcement sweep and yet another corresponding lockdown. During that sweep and lockdown, Mr. Combs was removed from his unit officers so they could search its contents. He was not entitled to be present for the search. Officers ruffled through his personal notes and left them scattered and out of order and disorganized. These notes included his work product and notes reflecting communications with defense counsel. The officers also seized Mr. Combs' pens, leaving him unable to take further notes while reviewing discovery or during counsel calls. As a result of the lockdown, defense counsel was delayed in meeting with Mr. Combs, losing time for trial preparation. Additionally, MDC does not permit counsel to provide Mr. Combs with even the basic materials necessary for trial preparation. We cannot equip him with the notebooks, folders, or physical documents, for example. How is a defendant supposed to completely defend himself or consult with the counsel in case of the magnitude without such basic materials? The problem is further compounded by the fact that the laptop we provided to the government nearly a month ago still has not been given to Mr. Combs, so he has no means at all to even take notes. Under the Fifth and Sixth Amendments, Mr. Combs is entitled to meaningful participate in a defense and collaborate with counsel. The quote-unquote traditional right to freedom before conviction facilitated these rights by permitting the unhampered preparation of a defense. Thus, under the Bail Reform Act, a detention order is only lawful to the extent it, quote-unquote, can afford a reasonable opportunity for private consultation with counsel, and it explicitly permits pretrial release when necessary for preparation of the person's defense. Although the Supreme Court has rejected facial challenges to the Act's procedure, it has not determined whether or not they may be insufficient in some particular circumstances. Keeping Mr. Combs detained under the extraordinary circumstances here would leave him unconstitutionally handicapped in consulting counsel, searching for evidence and witnesses, and preparing his defense. Indeed, it is well documented that pretrial custody is associated with the ultimate outcomes of cases, with released defendants consistently faring better than the defendants in detention. ABA standards for criminal justice, that is even more likely to be the case here, where detention is stripping the defendant of any real opportunity to review evidence against him or otherwise prepare for trial. For the ongoing reasons, and to ensure fair trial and protect Mr. Combs' constitutional rights, the court should order release on the proposed conditions or any of the conditions that the court may deem appropriate. Signed, November 8th. So Diddy wants to be free while they do all the discovery and whatnot. Okay, let me put up the next document. Hey guys, thanks for being here. I appreciate it. Moving on. Okay. So I'm trying to go in order as they were released on through the court system. So let's see. New declaration, Diddy. 𝗟𝗄E, I binge watch your videos on. Oh yeah. Hey, life artist, good to see you. Thanks for binge watching. Okay, let me share. So now we have the declaration. This was filed the same day, November 8th. Declaration of Mark Agnifilo. This is only 2 pages. In support of the renewed motion for bail. So that document that we just read, this is in support of. I, Mark Agnifilo, declare as follows. I apologize if I'm not saying that right. I am a partner at the Agnifilo Intre LLP counsel for Sean Combs. I am licensed and in good standing to practice in the state of New York, and I also am admitted to the United States District Court. The declaration is based on my personal knowledge of the facts stated herein and submitted in support of Mr. Combs. attached here to Exhibit 1 is a true and correct copy of blank and produced by the government with an attorney's possession only designation pursuant to the protective order. So I do have those exhibits. They're sealed right now, but as soon as they're unsealed, I'll be able to see them. Whatever it is, it's blacked out here. And it's also blacked out in the next 3 spaces. So it says attached here is Exhibit 2, which is the correct copy of blank and is also designated pursuant to the protective order. And then there's another document, Exhibit 3, which is sealed. And then there's an Exhibit 4 and 5. So I should have access to those as soon as they become unsealed. There's a lot. What are they sealing? What are they sealing? What is this? Look at all this. Public information, sir? I don't think so. November 8, 2024. This is not public information, sir. No, Mr. Judge. No. Oh, I'm sorry. This is Mark Ignifilo. Still, no judge and no Mark Ignifilo. What is this? Who is in here? Who is named here? We need to know. We need to know. And I'm just being nosy. Okay, let's move on. I'm just messing with you guys. Okay, last document regarding the bail. And then we're going to read the new lawsuit, which is only like a couple pages, so it's not very long. Okay, so memorandum and opinion. Let me share it on my screen. Diddy is just... it's too much for me. Okay, let me know if you guys can see this document. This is dated also November the 8th. On October 28th, 2024, opinion and order document. Defendant Sean Combs moved from an order prohibiting prospective witnesses and their attorneys from making extrajudicial statements that he argues will substantially interfere with the right to a fair trial. In terms of who those protective witnesses are, Combs clarified that the category includes all those who claim to be victims. The government opposed this victim gag order as extraordinary and beyond the purview of local rule. For reasons below, the motion is denied. This is their answer. They're like, no, you're denied again, baby. Combs authorities don't support a gag order applicable not only to trial participants, but also to any alleged victim and lawyer. I do not authorize this kind of relief. The limitations of the rule don't apply even to witnesses, let alone prospective ones that have yet been identified. They certainly do not apply broadly to any alleged victims and their lawyers. And to impose a special order, the court must consider whether it will, quote unquote, be necessary to ensure an impartial jury and must find that other, less extreme, available remedies, signally or collectively, are not feasible or would not effectively mitigate the pre-trial publicity and bring about a fair trial. Among these remedies, the court is required to consider are, quote unquote, a searching voir dire, emphatic jury instructions, and a sequestration of jurors, matters that Combs hasn't addressed. A gag order under Rule 23 is an extreme remedy to be issued only as a last resort. What Combs seeks goes even further. Okay, so basically they're saying that when the trial happens, they're going to sequester the jury. Yeah, right here it says he hasn't addressed that. Jury will be sequestered during this trial, which I could see that, right? I don't know. How do you guys feel about that? Combs' Sixth Amendment authorities don't support his proposed order either. In Shepard versus Maxwell, the Supreme Court observed that the trial might well have been prescribed extrajudicial statements by any lawyer, party witness, or court official which divulged prejudicial matters, but it did not indicate that the blanket restrictions on potential witnesses or even more broadly, all alleged victims would be inappropriate. The court only suggested that trial courts in appropriate cases limit what the contending lawyers, the police, and the witnesses may say to anyone. Combs' other cited authorities are similarly unhelpful. Each allows some restriction on trial participants or the press, but says nothing about potential witnesses. The only decision Combs identifies that appears to involve a bar on speech by all the potential witnesses is United States versus Brown, in the case that the district court imposed a gag order prohibiting parties, lawyers, and potential witnesses from making extrajudicial statements. While the Fifth Circuit upheld this order, it described the order as only affecting the attorneys, parties, and witnesses. The Brown court certainly did not address the sweeping First Amendment implications posed by a gag order applying to all alleged victims and their lawyer. But the Fourth Circuit in Murphy and Brown did. The case dealt with an order very similar to what Combs seeks here. Given the unclear yet extraordinary reach of the phrase potential witness, which cannot help but impair legitimate news gathering activities in and of themselves, underlie the proper function of the First Amendment, and assume all covered individuals identically situated pending further litigation, the court rejected the order as exceedingly what would be essential to the preservation of a trial. The Fourth Circuit was also skeptical of how the order would impact more than 20 cases that would be tried in a period of years. The court has an affirmative constitutional duty to ensure that Combs receives a fair trial, but the essential Sixth Amendment requirement must be balanced with the protections First Amendment affords to those claiming to be Combs victims, especially because prior restraints on speech are the most serious and the least tolerable infringement on a First Amendment rights. The author of the Bill of Rights did not undertake to undersign priorities as the First Amendment and Sixth Amendment rights, but the case law gives clues as to how to mediate between them and when they come into conflict. I'm going to skip like a bunch of this like law talk. To the extent Combs has a particular concern regarding statements made by attorneys for grand jury witnesses, the court reminds counsel that the local rules clearly state, with respect to a grand jury or other pending investigation of any criminal matter, a lawyer participating in or associated with the investigation shall refrain from making any extrajudicial statement if there is a substantial likelihood that the dissemination will interfere with a fair trial. As to statements by the grand jury witnesses themselves, any grand jury witness may disclose publicly anything that occurred herein. But courts do have discretion to impose a reasonable obligation of secrecy or grand jury witnesses. But Combs has only raised statements in the media from a single grand jury witness. He hasn't made an adequate showing why a blanket gag order on all grand jury witnesses is warranted. There we go. The court is like, no. Yay! Thank you, my traveling gypsy tarot, for becoming a member. I appreciate you. Aw, Bun Bun. We love you, Bun Bun. Thank you, my traveling gypsy tarot. Let's see. I'm just gonna skip this like legal talk because I'm over it. Balancing the interests at stake, the court has already taken steps to limit what I mean is like all the codes and all that information. Balancing the interests at stake, the court has already taken steps to limit what can be said publicly, including issuing an order underscoring the requirements in local rule and further requiring the government to make those specific requirements clear to anyone involved in the case. As the court stated in that order, it will take appropriate action for violations of the rule or this court's order. The court is open to other tailored proposals that will help ensure a fair trial. As to the mounting civil cases against Combs, there are further steps he can take, including seeking relief in particular cases if the parties or their lawyers have made prejudicial statements to the press, or moving to those cases pending the resolution of this one, just to give two examples. However, the unprecedented relief that Combs seeks on this motion is unwarranted. The clerk of court is respectfully directed to terminate the motion. So ordered on November 8th. He keeps being denied left and right, huh? All right. I'm going to read, that was on November the 8th, all those bail documents, and I just got the one from yesterday. It's like one page. It really says nothing, but hey, at least we're going through it. We're almost done. Thank you guys for being here and like going through this Diddy stuff. It's crazy. So I'm going to go through the document from yesterday and then the new lawsuit that well, it's not new, but it's recently entered the court system. So this is, I think it's Diddy's lawyers. Oh no, Damian Williams, United States Attorney. It says, Dear Judge Subramanian, following the defendant's motion for bail filed yesterday, the government respectfully submits the following schedule. The government files its opposition by November 15th. A hearing scheduled for November 21st or 22nd or any time thereafter convenient for the court, but avoiding the week of November 25th. The government has conferred with defense counsel who have indicated they do not object to the government filing its opposition on November 15th, that they are unable November 18th, and they request a hearing on November 22nd. Defense counsel also indicated that they wish to submit a reply brief by November 21st. The government believes that this reply brief is necessary, but to the extent the court permits a reply, respectfully requests that it be filed in advance of the hearing date. So the district attorney is, I'm not a lawyer, but they're pushing things, right? The government files its opposition by November. That's on November 15th is like next Wednesday. I don't know. I don't have a calendar right in front of me. So they want like a response fast. They want to move with this fast. November 22nd or 21st. Anyways, that was a motion filed yesterday. Gracie, my love, thank you for gifting a membership. I appreciate you so much. Who became a member? Yay, 4 Chihuahuas! I appreciate you guys for being here. You guys are awesome. Okay, so let's move on. Last document. This is the newest complaint. Gracie, I appreciate you, my love. You know you're a good friend, and now you're my mod, and I appreciate you very much. Let's move on. Okay, so this next document is the newest complaint by someone who had an interaction with Diddy back in like 96, but it just now hit the court system. So we're going to go through it. This person, DeWitt Gilmore, has been on a channel that I mod for, Pascal. He did an interview there. So I will link it in my description so you guys can go and watch it. He came onto his channel way before this document hit the court system. So this was on November 3rd. But he's been talking about his situation and experience with Diddy for quite some time. Aw, I appreciate you, my friend. You're so precious. Okay, so let's see. Complaint, DeWitt Gilmore. This is public information, so anyone can get this. I'm not doxing anyone. Plaintiff DeWitt Gilmore, by and through his complaint, states that following defendant Sean Combs, Bad Boy Entertainment, and any affiliated companies. Okay, so Diddy's responsible. New York. I'm going to skip that. Parties. Plaintiff DeWitt Gilmore, a resident of Atlanta, Georgia, is an author, entrepreneur, and public figure who suffered personal and emotional injuries due to the actions of defendants. The defendant is Sean Combs, who Mr. Combs acted individually and through his affiliates, including bodyguards and associates involved in the incident described. So whoever this Mr. Gilmore, DeWitt Gilmore, he is filing lawsuit against Diddy and his bodyguards. Bad Boy Entertainment, related entities, business entities operating under the direction of Mr. Combs, affiliated entities, any subsidiaries, entire entities, or individuals associated with Bad Boy Entertainment. On a night in the summer of 1996, plaintiff DeWitt Gilmore was assaulted by defendant Sean Combs and a group of his associates, including his bodyguard, on a street in New York City after exiting a club. Plaintiff, in the company of his friends Lance 𝗏𝗏 approached his vehicle on an Isuzu Trooper parked near the club. As plaintiff and his friends prepared to leave, Defendant Combs and his associates pulled up in a gold convertible with Defendant Combs positioned in the passenger seat and his bodyguard driving. Defendant Combs initiated a verbal confrontation with plaintiff, taunting him with derogatory language and escalating the situation with threats of violence. His words, including "What's up, bitch," were included to provoke and intimidate plaintiff. The encounter rapidly intensified as Defendant Combs' bodyguards and additional vehicles carrying armed associates joined to form an entourage surrounding plaintiff's vehicle. Defendant Combs and his associates blocked the plaintiff's car, creating a sense of immediate danger. Defendant Combs' associates brandished firearms and shots were fired. Fearing for his life, Plaintiff Gilmore, with Lance and Rico as witnesses, were aggressively chased through the dark city streets and managed to evade the scene by accelerating through traffic, narrowly escaping a potentially deadly ambush. As a result of this incident, plaintiff suffered significant emotional and psychological distress, a fear of retaliation, and harm to his reputation. He was unable to bring this case forward at the time due to Defendant Combs' considerable influence and power in the entertainment industry, as well as his fear of continued harassment and possible violent retribution. The plaintiff Gilmore recently reconnected with a key witness, Lance, after years of no contact. The reconnection brought forth new insight and testimonial evidence surrounding the events of that night, underscoring the intensity of the encounter with Mr. Sean Combs. Calf's account serves as a recently discovered evidence significantly enough to reopen the case beyond the usual statute of limitations due to the unique circumstances of intimidation and safety concerns that delayed either action. Mr. Calf's statement, obtained in September of 2024, corroborates plaintiff's experience of the attack and identifies Defendant Combs as a primary instigator, providing essential new information to this filing. Claims for relief. Count 1, assault. Plaintiff repeats and realleges each allegation as it is set fully forth herein. Defendant Combs and his associates, through threats and displays of violence, willfully place plaintiff in imminent fear of bodily harm, leading to significant emotional distress and mental anguish. Defendant's actions constituted assault under New York law, and plaintiff is entitled to damages for the fear and the emotional trauma suffered as a result. Count 2, battery. Plaintiff repeats and realleges each allegation as is fully set forth herein. Defendant Combs and his associates intentionally engage in harmful and offensive contact with plaintiff by surrounding him with an armed entourage, firing a weapon in his presence, and creating a physically dangerous situation. Plaintiff sustained damages, including physical and emotional suffering, as a direct and proximate result of the defendant's actions. Count 3, intentional infliction of emotional distress. Plaintiff repeats and realleges each allegation as is fully set forth herein. Defendant's actions, including threats, the brandishing of firearms, and a deliberate attempt to intimidate and harm plaintiff, were extreme, outrageous, and intended to inflict severe emotional distress. Plaintiff suffered significant emotional and psychological harm as a direct result of the defendant's conduct, entitling him to compensatory damages. Damages and relief sought. So he's looking for compensatory damages in the amount of $5 million for emotional distress, physical harm, lost opportunities, and reputational damage. Punitive damages as determined by the court to deter future misconduct by the defendants and similar parties. Cost of his action, including reasonable attorney's fees, should plaintiff retain legal representation. Any other relief the court deems just and proper. Demand for jury trial. Sunday, November 3rd, 2024. Hey, Lily. Good to see you, love. Melanie. Aw, bun. You know I love you. Thanks for being here. Okay, so we read through it. What do you think? This person from 1996, DeWitt Gilmore, has filed a lawsuit against Diddy for $5 million. So this is the most recent lawsuit as of 11/03, other than the bail documents. Wild. So wild. Anyways, I appreciate you guys for being here. We just got through the Diddy documents. I don't know. I don't know what to think about all this Diddy stuff. What do you guys think? Let me know. Are you guys Diddy fans? No Diddy fans? Anyways, let me know in the comments down below. I appreciate you guys for being here. I know that was a quick live, but we were just reading through those documents. And I hope to see you all in the next live. Bye.